Good afternoon. I'd like to welcome everyone to today's Board of Zoning Appeals meeting for Thursday, March 14th, 2024. I asked for Ms. almost said something else, Ms. Brown to provide us with, after calling the meeting to order, to provide us with roll call. Now I've called them to order, so go ahead, ma'am.
President Bonds,
Present.
Vice President Hawkins,
Here.
Secretary Jones. Here. Cook. Fawcett, Mr. Fawcett. We have a quorum.
Thank you, Ms. Brown. Next item on the agenda is the approval of the minutes from the previous Board of Zoning Appeals meeting. Do we have the minutes this time?
There are no minutes.
Okay. We will defer those minutes to be approved at the next regularly scheduled meeting. The next item on the agenda are the actual public hearing items. First will be the continued items, and the first item on the agenda is BZA 2024-1, 805 Grant Street, Home Daycare Special Use Permit. Is the petitioner, Princess Ward Bay, present? Do you wish to, well, staff like to provide, since this is a continued item, a refreshed overview? Go ahead, Mr. Arshami.
Gotta press the button. Press the button.
Can you hear me? Yeah, great. Yes, my name is Taghi Arshami. I'm a sort of interim director of the zoning. The petition 2401 is a continuation of a petition that was started last meeting you had, and the petition was, the petitioner had a error in its submission of the petition, and since then that error, the original application has been amended to correct that error, and I understand the petitioner, as you indicated, is here to answer further question. The petition is for a day care home, and in our last conversation or presentation, we did indicate that they generally meet the overall criteria that are for a special use permit. We have had a meeting with the petitioner, and they have been very cooperative and pleasant, and we have determined that they meet all of the criteria, and as such, we are recommending a favorable recommendation. This would be subject to two conditions. One, that the petitioner will maintain a fence around the property to prevent children from running into or onto Grand Street. And the petitioner also agrees to provide parking or maintain the parking on the back of the house in the alley, from the alley side, so the drivers or the parents can park there and drop their kids at that location. We do have also, I'd like to inform you that the petitioner has indicated there is a vacant lot next to the building. They don't currently own it next to this property, but the petitioner expressed an interest to acquire that lot, and I understand it's either privately owned or it's owned by the county, and to expand the site and for a additional playground for the kids. Based on those conditions, our recommendation again is favorable for the petition.
Thank you, Mr. Arshami. Counsel, it looked as if you wanted to interject. For the good of the body as well as the audience, what Attorney Pohl stated was we needed to make sure that staff was in possession of proof that the home was the actual residence of the petitioner, which is statutorily required by ordinance as well, in order for a home daycare to be eligible. Did I state that correctly, sir? For a special use permit for a home daycare to be approved. Is staff in possession of said document?
Yes, Mr. Document. Well, we have the documents, and, but if that is if the council feels more comfortable that we can put that as a condition, that this condition will be granted on the basis of continued ownership of the property, we have no objections to that. Reside,
Right.
I'm sorry, yes, let me correct myself, yes. That they reside, continue to reside.
She provided her homestead exemption, and she provided proof of ownership.
Ownership is not so much the criterion question, is residence. The homestead exemption, according to council, does give it the go, the clear. Anything else, council?
No, they notice that they have to maintain it as a residence. You know, this isn't the foot in the door. When you come and get your business license, you should also be demonstrating that you do still reside in the property. Every year, when you get your business license, you gotta demonstrate that you reside in that location.
So it sounds like we will be burdening zoning with the burden to ensure that the approvals that have the requirement of the residence being occupied by the petitioner remain as such. At this time, I do see Ms. Ward Bay in the audience. Ms. Ward Bay, would you like to approach the podium? Do you have anything you'd like to speak at this time? You don't have to. All right, thank you, ma'am. But for the sake of protocol, are there any individuals in the audience who wish to speak on behalf of BZA 2024-01? Are there any members of the public who wish to speak on behalf of BZA 2024-01? Are there any members of the public who wish to speak on behalf of BZA 2024-01? Hearing none, seeing none. Commission, you've heard the recommendation of staff. What is the board's pleasure?
Mr. Chair, I'd like to recommend that we accept staff's recommendation and approve BZA 2024-1.
Would you like to recommend or move?
Let me say with the criteria outlined as being necessary, the fence, the parking, that type of thing, and proof of residence.
You recommending or moving? Having been moved and properly second, are there any other questions on readiness? Hearing none, seeing none, roll call, Ms. Brown.
President Bonds,
Yes.
Vice President Hawkins,
Yes.
Secretary Jones,
Yes.
Mr. Cook,
Yes.
Mr. Fawcett.
Yes.
With the vote of 5-0, the
BZA 2024-01 has been favorably recommended. It's okay. Ms. Bay, congratulations. Any other additional information that may be required or steps can be provided to you by zoning. Thank you. The next item on the agenda of continued items is BZA 2024-02, 5160 Broadway Car Dealership Special Use Permit. Staff ready for a refreshed overview. Yes,
Mr. President, this is a continuation of last meeting. The petitioner is is planning to open up an existing car lot, a former car lot, and for a new car lot that we have met with the petitioner and the owner of the property. They are interested to renovate and improve the site. The site has been neglected for several years, and we, in our conversations on the site, they showed us that they are already have started and got a permit from the buildings improvement, and those have been completed while we were there. They were actually doing the cleanup, and that was, yeah, that was done. Based on the activities that's going on in the area, we have determined that the proposed use is suitable for the area. It's right on Broadway and 52nd, and therefore we have determined the establishment of a car dealership is appropriate for the site and the area, and as well as it doesn't create any issues with existing property owners or adjoining property owners, as well as it's the development itself is something that is acceptable in the district that is designated. With that in mind, we would like to recommend favorable for the petition, subject to the following conditions: that access to the site will remain to the side street, not on Broadway. And the other condition would be that all existing fencing, including those with barbed wire, which are almost gone, will be removed from the site. And all of the other conditions that exist on the site primarily that are contributing to the dilapidation look of the property will be all either removed and or replaced, like something like existing light poles. And the parking lot will be striped, and so it does look like a lot with a parking lot. And there are currently several storage containers on the site, and all of those we are also asking that either need to be removed from the site or on the front yard, or they need to be moved to the back side of the lot. With those conditions, and also the petitioner asked that if they could be given some time to implement these improvements, and our recommendation is that the BZA agrees to give them 6 months to do all the improvements, and so they can start their business.
Thank you, Mr. Asharmi. Counsel?
So a couple things. If I'm understanding correctly, there's a building permit that was issued already. Typically, we're not supposed, those building permits aren't supposed to be issued until the special use permit is issued. So I'm not really sure. You know, we're in the middle of a transition and stuff like that happens. But ultimately, if the request is their request and the staff recommendation is that there are the recommendations that are being made subject to, or approval subject to these recommendations, that's completely within the purview. Ultimately, the special use permit doesn't, when you issue these with the pending recommendations, the special use permit isn't granted until, technically granted until those whatever needs to be provided or whatever needs to be demonstrated is actually completed. Otherwise, you issue a special use permit and there's no, we would have to bring the individual back and go through the rigmarole of making that determination. So, in this situation, since they actually already have the building permits, is my understanding, we can do this subject to, you can do this pending the approval subject to the conditions, the conditions precedent. Yeah.
Of the special use.
Yeah.
Does it still have to go before council?
Still has to go before council still too, and that they can either include the more recommendations, they could, you know, essentially what we're doing is sending a recommendation to the council for their approval, so.
Okay. Thank you, Council.
Mr. President, the improvements that were made interiors, I understand it was related to plumbing and electrical improvements, not the building.
Repeat that, please.
I understand the improvements that were made to the building were related to the system improvements, electrical and air conditioning and plumbing. Not the building.
So it sounds as if two things can be true at the same time. In order to make the improvements that are construction related, the city would require a building permit to proceed with those work items.
Right.
The special use permit is usually needed, or not usually, is for the most part required in order to get the permit. But then if they were doing the work without the permit, so before we go any further, I think we know where we need to go with that. Is the petitioner present? And if the petitioner is present, do you wish to speak on behalf of BZA 2024-02? You don't have to. All right, thank you. Having heard the recommendation of staff of a favorable recommendation, subject to the conditions, let me back up a minute. Is Mr. Asfer available? Mr. Asfer, will you please approach the podium for me? State your name and address for the record. I'm going to take a little bit of liberty here.
For San Asfur, the address of the place or my address?
Your address.
15645 Waverly Avenue in Oak Forest, Illinois.
Okay, thank you. Mr., am I pronouncing this right? Asfer? Am I
Yes.
saying that correctly? Ashfer?
Asfur, yes.
Asfer, okay. Are you aware of the conditions that the zoning staff have made that are required? And should the board vote favorably towards their recommendation, that you are required to meet in order to receive this special use permit? And do you concur?
Yes, sir.
And let the record reflect that Mr. Asher has recognized he concurs with the conditions that must be met. Thank you, Mr. Ashfur. Having heard the recommendation of staff, what is the board's pleasure?
Just a quick question, though. Was there a time frame associated with the recommendation?
6 months. According to staff, which is also a part of the recommendation, the condition. The petitioner has 6 months to satisfy the conditions in order to obtain the special use permit. That's part of the conditions.
I move for approval of BZA 2024-02, subject to the staff conditions as presented.
Thank you.
I'd like to second it, Mr. Chair.
Thank you, Mr. Cook. Having been moved and properly second for a favorable recommendation with the stated conditions and timeframe, are there any other questions or readiness from the board? Hearing none, seeing none, roll call, Ms. Brown.
President Bonds,
Yes.
Vice President Hawkins,
Yes.
Mr. Secretary Jones,
Secretary, yes.
Mr. Cook,
Yes.
Mr. Fawcett.
Yes.
With a vote of 5-0, BZA 2024-02 has passed.
Thank you, Ms. Brown. Mr. Ashford, congratulations. Any further steps or requirements will be remitted to you by the zoning department. I do encourage you to request those conditions if they have not already been remitted to you in writing so that you know what you have to do in order for those conditions to be met. Let the record also reflect that I believe it is the opinion and advice of council that the permit be withheld until those conditions are met, given the snafu with the building permit.
We could, I mean, ultimately, it's gonna be up to the council whether or not that, that's the recommendation. They can call them back.
She doesn't have it written in here.
Okay. Okay, all right. Thank you, Mr. Ashford. Go ahead.
The gate that you guys want me to take down, he told me the backside I don't gotta take it down. The one by the liquor store,
That part, I'm going to encourage you not to have that conversation here, but you can have that with Mr. Arsami and Ms. Brown and the zoning staff. That, we don't need that right now.
all right, I'm just asking.
But thank you. That's not to cut you off or be disrespectful, but that's probably, not probably. It's better to have that conversation with them to ensure that you have a complete and full understanding.
All right, but at the same time, I was trying to see if I get a business license to open up, and I could do it in the same time. It's not gonna take a week or two, just.
Well, that's not in our purview.
You won't be able to get a business license until you get the special use permit, which still has to go to council. It should be a couple, there are 2 hearings on that,
Right.
so you won't be able to get a business license today. This is
I know,
a
I'm not saying today.
Yeah. So
There's-
once you have a special use permit, you'll be able to get a business license, but that won't happen until the council issues that to you.
So how long is that for?
You'll have a hearing set at the potentially at the next council meeting, and then it'll go to a committee, then it'll come back for another council meeting, and they'll have to do, it's considered a 3-reading hearing. It's an ordinance, so.
All right. All right, thank you.
Thank you, sir. Next item on the agenda, BZA 2024-03, 8525 Lakeshore Drive Residential Development Standards Variance. Is staff ready to refresh the board with the overview?
This is, Mr. President, this is a continuation of a previous petition that you heard, and the petitioner was here. This is a sort of good story report and reflects your effort and the staff's effort, particularly under the current administration. And it is important to note that this petition was initially filed in March of 2023. And it was not, for some reason or another, it was not approved. We did have a chance to talk to the petitioner. The petitioner wanted to have 3 different standard variations, and they, after several phone calls and conversations, the petitioner agreed that basically it's, for them, it is better to just give up on those variances. And they decided to withdraw their petition and start building it. And based on this sort of revised plan that met all of the city's standards and development standards. And so in that respect, you have in your package, you should have a letter from him stating withdrawal, and we are recommending for you to accept that withdrawal request. Can you?
Thank you, Mr. Arshami. While you look for the letter, just for the sake of clarity,
You have the email and before you leave with it.
that's fine. I don't know that we need that to make a decision if the petitioner has decided to withdraw. And that withdrawal is based off the fact that it doesn't appear that they need it to come before us. So is Mr. Peterson present? Okay. We'll let the record reflect that we sincerely apologize for the mishap and the time associated with it. But I don't think we need to prolong this any further. Having heard the recommendation of staff, of the petitioner desiring to withdraw their petition because the existing uses meet the existing zoning standards. What is the board's pleasure?
I'm waiting to write. Somebody has to do it.
I move for approval of withdrawal of BZA 2024-03 per the request of the petitioner.
Thank you, Mr. Hawkins. Thank you, Mr. Cook. Having been moved and properly second to accept the staff's recommendation of withdrawing BZA 2024-03. Are there any questions on readiness? Hearing none, seeing none, roll call, Ms. Brown.
President Bonds,
Yes.
Vice President Hawkins,
Yes.
Secretary Jones,
Yes.
Mr. Cook,
Yes.
Mr. Fawcett.
Yes.
With a vote of 5-0, the withdrawal of BZA 2024-23 has passed.
Thank you, council. Staff, Ms. Brown, sorry. Next item on the agenda is BZA 2024-05, 1325 through 27 East 37th Avenue, towing and storage facility use variance. Staff prepared to provide us with a refreshed overview. Mr. Arshami.
Yes, Mr. President, the petition is for a development of a school, a CDL school on a property off of Klein Avenue that is totally residential. The whole block is residential. And currently, there are a couple of buildings on the site indicating that number
You're
five.
reading the CDL training facility, Mr. Arshami, when this should be the towing and storage facility according to the agenda.
Tour and historic.
2024-05. 03.
For some reason, my apologies, I was, or my staff thought that this was our recommendation, as you may recall, was for denial, and I'm sorry.
You're reading 07. 07 is the one that you were just reading.
Right, I'm going back to '05. Yes, and they, I do not have those records, I'm pretty sure you do, and, but our recommendation last time was out of the concern of the condition of the site that we recommended a denial. In, I think the staff is correcting me, said, no, we did not, but nonetheless.
The last meeting, we discussed that Mr. Rogers' green and white cards were not in the folder.
Right.
But I found the green cards. And so he was continued because we said we didn't have the green cards.
Okay. Although that was one of the reasons, but our recommendation was for denial of the petition based on the condition of the site and a potential condition, future look of this development. Currently, there are a number of, it's a storage yard with a lot of abandoned materials on the site. There is a railroad track on the back of the property, and the current owner also owns another lot immediately south of this lot. That the concern for us and for the staff is that that area is not suitable for another, due to its close proximity to I-65 primarily, and it's not suitable for a truck facility. Although the petitioner is indicating that it will be just going to be a towing facility, nonetheless, the condition exists there that would lend themselves to development of a site being becoming another storage facility in the area. For that reason, our recommendation was denial.
Okay, I wonder if we have a minor error. This is 2024-05, 1325 through 27 East 37th Avenue. Towing and storing facility use variance. But there's also a petition to use the property as a commercial senior assisted living home. Typo, that's what I thought. So,
We have to fix the agenda. Yeah,
the title is correct. The supporting description isn't. So, council, is this something that, by way of a motion, a member can amend while we're here and then make the necessary corrections for the record thereafter?
It's obvious that the title of it is the correct notice that this was the item that's going to be there. It specifically lists towing and storage facility. You know, we can do a motion to correct, and amend, the agenda to correctly reflect the description on the agenda for BZA 2024-05.
Thank you, council. So here's what has to happen. Correct me if I'm wrong, or what I would suggest in support of what Attorney Pohl has indicated is perhaps staff from the supporting documentation should read what the agenda item should state. And then as such, if it's the board's pleasure, move and second to amend the agenda so that we can move forward with the item as presented. If that made any sense. So, and help us out here, council. I only play one on weekends. We're gonna have to motion to amend the agenda today, to reflect. Because what's on the actual agenda itself is not the description provided in the supporting documentation for BZA 24-05. We need to amend the agenda to read or be heard as described in the supporting documentation.
Mr. Chair, I'd like to make a motion to amend the agenda, correct it, and have it reflect what is described in our actual supporting documents, not which is described on our agenda.
That makes sense, sir.
Second.
Having been moved and properly second, are there any questions on readiness? I'll just say this, make sure, Ms. Brown, that we go back and make sure that the record, the written record reflects the actual change so that your records will show that the agenda reads the way the actual description and the supporting documentations read. But I am gonna have either you or Mr. Arshami read it for the verbal or recorded record today, and those who are attending by way of Zoom. That sound amenable, council? But that being the case, let's first take the vote.
President Bonds,
Yes.
Vice President Hawkins,
Yes.
Secretary Jones,
Yes.
Mr. Cook,
Yes.
Mr. Fawcett.
The description as presented on the agenda, the title is correct, the supporting description is wrong. It is correct, however, on the supporting documentation within the petition. We're voting to amend the agenda today so that we can still hear it and have the record corrected in writing after the fact.
With a vote of 5-0, the
Agenda has been amended. Thank you, Ms. Brown. Now, either you, Mr. Arshami, or you, Ms. Brown, can read the description as presented on the supporting documentation.
The petitioner and lessee is Jamal Rogers. The affected real estate is 1325 through 27 East 37th Avenue, Gary, Indiana. The parcel number is 45-08-27-227-005.000-004. The legal description is Great Gary Realty, COS, First
Edition.
Edition, Block 14 lots 1, 2, 3, 4, 5, zoning district R2. The petitioner Jamal Rogers requests a use variance in accordance with section 123-107 to use the property as a towing and storage facility.
Thank you, Ms. Brown. Mr. Arshami, you may now proceed if you are prepared to give us the actual correct overview.
I can provide you, Mr. President, an overview as I stated earlier, and you have previously received the full documents on this petition, and we felt that the petition, with its location where it is, it does create issues on several fronts as outlined for a use variance requirements. The primary concern for the petition is its impact on the neighborhood, as well as the site itself, as well as its overall regional impact that may have. The site is located across from a residential neighborhood. It has immediately on the south side of the 37th Avenue, which is also Ridge Road, have other development, business park type of development that just do not lend themselves to establishment of a storage yard and perhaps a truck yard. The facility currently is occupied and with a lot of storage type of materials, as well as trucks, trailers, and we feel that that area is not suitable for that purpose. That's also contrary to what the comprehensive plan calls for the Ridge Road corridor, particularly in that section of the Ridge Road that is close to I-65. That was the basis for our unfavorable recommendation.
Were you finished?
Yes.
Thank you, counsel. Okay. Is the petitioner, Mr. Jamal Rogers, present? Mr. Rogers, do you wish to address the staff recommendation regarding your petition at this time?
Yes.
Please state your name and address for the record.
My name is Jamal Rogers, 130 East 49th Avenue, Gary, Indiana, 46409.
You may proceed, sir.
I petitioned to, I guess, reactivate the previous business license, which they told me I couldn't because it was grandfathered in under affordable towing. So previously, it was done as affordable towing, but of course, Ronnie sold the yard to me. So once I have the yard, it was out of commission for 2 years. So once it's out of commission for 2 years, you have to reapply. The business license goes back, well, the location goes back to residential because previously it was already used as a tow yard. But once you don't use it for 2 years, you have to go back to residential. So now I'm applying to get it back zoned again for towing and storage once again. And I didn't understand how it went back to residential when across the street, there's a gas station. Next door, there's a body shop. On my same thing, there's a body shop. Then there's another commercial building right next door. So I was just trying to reapply to get it reactivated once again for a, it's just another name change, I want to say. That's how you all want to look at it, a name change. But as moving forward, any conditions or anything that they have for the location, I'm willing to fix immediately, right away, because anything, I've been going through this process for, I want to say maybe close to a year. Anything that, you know, Poe or Ms. Brown or the lady previously before her asked me to do, I'm Johnny on the spot. I try to take care of everything right then and there. The things they said wasn't possible, I made possible in a timely manner. So, and I've been down here every week since the last meeting, trying to make sure everything was on point for this meeting. Even the cards that she said that she didn't have, I had a receipt in there. So I was willing to go home then at the last meeting to show you all the cards were in. There was no petition, no objection from anybody in the neighborhood from the list of, I think 47 people that she gave me that had to be notified, certified mail. The sign is posted out there saying that anybody had any objections, they would be able to come forward. There were 0 objections. There was nothing to be said about the location being rezoned or have a special use variance in order to use it for a tow yard facility or storage facility.
Thank you, sir.
All right.
Are there any questions or comments before I call for any motions or comment myself from the board? Yes, sir.
No. Not that I know of.
Counsel?
So, Mr. Rogers has been, attempting to locate a tow yard here in the city for a while. I believe this used to be Affordable Towing. If anybody knows Ronnie Major, Affordable Towing, that was a longtime towing company here in the city of Gary. This is that lot. So when Mr. Rogers was referring to how he didn't know that it went back to residential after it was previously used as a tow yard, the reason for that is Mr. Majors had that lot for several years. He ran that business for decades prior to the enactment of the code in which these parcels were rezoned as residential. As such, once that was discontinued, it became a non-conforming use and no longer a legal non-conforming use. So it reverted back to what was ultimately passed as the residential lot or the residential zoning for that area. He's requesting a special, or it's not a special use, but a use variance because it is residential. It's not listed, tow yard is not listed as a special use or something that would be permitted by special use, so you would have to get a use variance. You'd have to demonstrate that it would be a hardship because of the way that the lot is, designed and associated and the way that the property or the condition of the property and the way that the structure is, whether or not it's designed as such. We've had this happen before where people come forward, they want to use a house for a business. So obviously that's not a hardship because they're using the house as a business, which it's supposed to be a house. In this instance, that's not necessarily the same case that the house is not, it's not a house. It was previously a tow yard. So that would be something to demonstrate, well, there is a potential hardship here. And I will give him that. So, ultimately what Mr. Arshami had pointed out was that, that this was a parcel in which, was located somewhat close to I-65. I believe this is off Central Avenue. Is that, if I'm not mistaken, close to Central?
Mississippi and,
Oh, Mississippi, that's right. 37th of Mississippi. So, there is whether or not this falls within the comprehensive plan. That's what I wanted to make sure we pointed out. The packet that was prepared, that's not the correct address. That looks like that's the wrong one. But for that area, if you go to other parts of our, one of our other packets, it has the full comprehensive plan. This area is considered, hold on, in our comprehensive plan, we'll go to the last one because it's got the full part on. This area would be considered, it looks like flexible residential, with flexible commercial as well, listed in there. And as such, I mean, it becomes a matter of, you know, does this meet the other particular characteristics of the neighborhood? You know, in that area, I mean, there's a body shop that I believe is right across the street.
No, the gas station across the street, the body shop is not directly joining the neighbor.
Okay. It's potentially contiguous. You know, it becomes a matter of, does the BZA, you know, agree that the characteristics of this area should change and we should stop providing this, assuming that, you know, the other characteristics are going to change, or if these businesses are going to continue, do we want to allow a use variance under these conditions on that?
For the edification of the board, council, can you provide us with an accurate interpretation of flex residential and flex commercial?
So with flex commercial, that indicates that that it's, you know, commercial establishments are allowed. It doesn't provide for industrial, it doesn't provide, it basically is much more discretionary to the BZA as to what type of commercial they want to allow in there without it being uncharacteristic of the neighborhood. So, you know, in this instance, because there are other locations, you know, there are other facilities that are around there that are similar in character, it would potentially be something that's within the discretion of the BZA, that it wouldn't be arbitrary and capricious to either grant it or essentially, you know, deny it ultimately. I mean, it becomes really a judgment call as to whether or not the BZA would like that to proceed, in that, you know, that there would be a tow yard there adjoining to a body shop and you know, across the street from a gas station.
Thank you, council.
Mr. President, could I just make a comment about the flex commercial? Throughout the comprehensive plan, that term has been used at different locations, and typically it means what we commonly call a business park. And smaller, not a small building, but smaller businesses aggregated into a larger building for flexible space to conduct business. So it is more of a business park than industrial.
Thank you, Mr. Arshami. Okay. I have just a couple of comments before I ask the questions, because let me get this question out, Mr. Cook. Not question, but this comment out. The only reservation I have heard as an individual voting member on this body is the petition and petitioner's contradiction to the comp plan. That is what's supposed to drive us, amongst other statutory criteria. Next sentence. Then there are words like potential acceptable hardship. You explain flex commercial, previous non-conforming use, that if in the event the parcel was sold while it was still operating within a certain period of time, it still would maintain, I'm looking as if I'm asking, that non-conforming use. But due to a lapse of time, it reverted back. Would that be a correct observation?
No, when you have an item that is, or when you have a parcel that is granted a use variance, it's a permanent use, or it's a permanent variance for the use that was applied for. So this would potentially be, until the zoning, somebody came and changed the zoning for a reason, this would be this would grant a use there wouldn't,
Okay.
if he ceased operations in 2 years, 3 years, for whatever reason, closed the place down, anybody who bought that parcel.
Because it's a use variance, not a special permit. There you go. Okay. All right, Mr. Cook, you had a question.
This, I understand the towing part, but what would the storage part entail? What would you store?
But right now, it was old cars and trucks that was previously there, that's still there from the previous user. There's no house there at all, period, so everything is already fenced in and locked in, and the same cars and everything else is still there, so there's gravel top there already, so. Did I completely answer it? Because I'm making sure I answered it for you. Okay.
And then there's only one thing, if I may take the liberty that, and I'm certainly not questioning staff's recommendation, so please don't take it as such. Just trying to be fair. If Mr. Rogers had those green cars last board meeting, I wonder what that decision then, what decision would have been made then? He couldn't obtain them. And I think we kind of gave the inclination that if he had them, we would have.
And they were in.
Discretionary. I mean, it's really, this one is.
And not to cut you off, counsel, I'm sorry, please keep going, and then they were here.
Well, I will say this, that was kind of a non-starter. If we didn't have proof that the service had been done, we didn't have proof that service had been done.
Any other questions for the board? And if not, what is the board's pleasure?
Mr. Chair, I would like to recommend that we approve BZA 20-24-5.
With a favorable recommendation or approve, concur with staff's recommendation? Go ahead, counsel.
Sorry. You have a very good question. I want to make sure I answered it correctly. I've got the chapter 6. Stating that transition needs to happen over time to another role. On the other hand, it's vacancy, disinvestment. You have, an individual that's looking to open up a
So does the board understand what Attorney Pohl just said? That essentially the way was that the statute
This is the,
or ordinance?
yeah, this is our comprehensive plan that we passed.
The way the comprehensive plan reads, if my interpretation is correct, it actually supports both points. So I do believe Mr. Cook was making a motion. We just wanted to have clarity if he was motioning to approve and accept staff's recommendation or otherwise.
My motion is to grant the petitioner the right to move forward with this.
Is there a second?
I second.
Having been moved and properly second, are there any questions or unreadiness? Hearing none, seeing none, Ms. Brown?
President Bonds,
Yes.
Vice President Hawkins,
Yes.
Secretary Jones,
Yes.
Mr. Cook,
Yes.
Mr. Fawcett.
Yes.
With a vote of 5-0, BZA 2024-05 has passed with a favorable recommendation.
Thank you, Ms. Brown. Thank you, Mr. Rogers. You will obviously be in contact with the zoning departments for the remaining steps and procedures that must take place.
Good luck to you, buddy.
Next item on the agenda are the newer public hearing items, BZA 2024-07, 2129 Klein Avenue, CDL Training Facility, use variance.
Mr. President, now it is time for this petition. The petitioner is Ariano Trucking, Inc. It's a Gary business that is proposing to establish a CDL training facility on this location, which is right on off of Klein Avenue on 22nd or 21st and 29 Klein Avenue. The area that the facility is located is primarily residential, although there are several vacant lots there, and there are also other uses that are similar in character at this location. We have received some information, including a floor plan as of last night. So we have not had an opportunity to really review and better understand the operation of the CDL facility. We have talked to the petitioner, and the petitioner has agreed to meet, I believe, next Thursday to discuss the plan, and then we would like to ask you for deferral of this petition to the next meeting, and so when we meet with the petitioner, we can collect all the information that is needed for our evaluation.
Thank you, Mr. Ashami. I don't see the need unless council encouraged me to do so, to open up for any other discussion outside of voting to defer.
I would say, I mean, because this has been advertised.
Leave it open.
The agenda items are open, letting individuals know that they can still be able to participate in public hearing at the next BZA meeting.
That doesn't require a motion, just the stating. Okay. Well, having heard the recommendation of staff to defer BZA 2024-07, 2129 Klein Avenue to the next regularly scheduled zoning meeting, what is the pleasure of the board?
So moved, Mr. Chair.
Is there a second?
Second.
Having been moved and properly second, are there any other questions or unreadiness? Hearing none, seeing none, and let the record reflect that the hearing portion of the item is being left open until the next meeting as well. so that any public comment or comment can be provided. Roll call, Ms. Brown.
President Bonds.
Yes.
Vice President Hawkins. Secretary Jones. Mr. Cook. Mr. Fawcett. With a vote of 5-0, the motion for BZA 2024-07 to be continued until the April meeting, the next scheduled meeting, has passed.
Thank you. Next item on the agenda is BZA 2024-08, 903 Warren Street, short-term rental special use permit. Staff ready with the overview.
Mr. President, the next two petitions, actually the same petitioner is applying for a,
Hold on a second, Mr. Arshami. Going back to a conversation we had with council, is Ms. Hecht present? And I do believe we discussed, if Ms. Hecht wasn't present, that we probably should defer this until she could be. Leaving the agenda item open. So there's no need to provide an overview, but you can provide us with a recommendation, even though I just kind of said it. But that's your prerogative to say it and mine to entertain.
it's your decision, Mr. President. We have reviewed it. We can continue to the next meeting and provide you with the same review or recommendation. If you like to hear it today, we will be
No,
happy.
that's fine. Having heard the staff's overview, to defer this item due to the petitioner not being present, and do we have to take action on them separately or collectively?
I would take them, I would do them separately, just.
Okay.
Right.
To defer BZA 2024-08 until the next regularly scheduled meeting. What is the board's pleasure?
So moved, Mr. Chair.
Is there a second? Having been moved and properly second, are there any questions on readiness? Roll call, Ms. Brown.
I have a question.
Okay, yes, sir, Ms. Cook.
Is this Airbnb, an Airbnb request?
Yes,
Yes.
Okay, just wanted to make sure I
Yes.
understood. Okay.
it may not be specifically Airbnb, it may be one of the other,
You second that, then you,
allows you to use whatever service you want, whether that's Airbnb, VRBO,
you second that, right?
My Stay Vacation, or whatever the other ones are.
Were they?
All right, thank you.
Oh, okay. Okay. All right, are there any other questions on readiness for BZA 2024-08? Oh, hold on just a second. We didn't open this up for public portion because I didn't think we were gonna have any. So at this time, we probably can't. Right. But you're not the petitioner, are you?
No, I'm not.
Okay, so what we're doing is we're deferring it. We did not open it up for discussion, so it's not proper at this time to take it.
You can leave whatever written, if you have written testimony that you want to submit.
I don't have any written, that's why I appeared here personally.
You can remit that information to staff, and we would encourage you to come back if you were going to speak on behalf of or in opposition to BZA 2024-08 when it is heard again at the next regularly scheduled meeting. Thank you, sir. I do apologize. Where were we? Moved and properly second. Are there any questions? Roll call.
President Bonds.
Yes.
Vice President Hawkins.
Yes.
Secretary Jones.
Yes.
Mr. Cook. Yes. Mr. Fawcett.
Yes.
With a vote of 5-0, the motion to continue BZA 2024-08 has passed.
Thank you, Ms. Brown. Much like the prior BZA item, BZA 2024-09, 6289 Ironwood Avenue, short-term rental special use permit is also represented by the same petitioner who also is not here. So without going into an elaborated discussion and not having anyone to speak on behalf or in regard to would staff recommend also deferring this one to the next regularly scheduled meeting?
That would be, yes, Mr. President, I do have a question from the council. And as you may be aware, for short-term rentals, we are very much bound by the state statutes, which they do put 30-day limit for any actions to issue a permit. And I don't know what this deferral impacts that statutory requirements in, so without, if there is no impact from that or no requirement on the part of the BZA to address that issue, I have no objections for deferral.
Council, did you hear that?
Yeah. Is that the statutory requirement just only applies to the council or both?
Well, while Attorney Pohl is checking it, we can't hear it without them here today anyway. So the burden of petitioning is on the petitioner.
Right.
Having heard the recommendation to defer BZA 2024-09, while Attorney Pohl verifies the criteria, until the next regularly scheduled meeting, what is the pleasure of the board?
So moved, Mr. Chair.
There's, having been moved and properly second, are there any other questions on readiness? Hearing none, seeing none, roll call, Ms. Brown.
President Bonds?
Yes.
Vice President Hawkins? Secretary Jones? Mr. Cook? Mr. Fawcett?
Yes.
With a vote of 5-0, the motion to continue BZA 2024-09 has passed.
Well, right.
Even if it were the case, we've already had
Right. So, next item on the agenda, if we may move on, we want to make sure, Attorney Pohl, thank you. BZA 2024-10, 1754 Arthur Street, home daycare special use permit. Staff ready with the overview.
Mr. President, this is a petition for a daycare home, establishing a daycare home by a property owner that evidently does not plan to reside in the property and carry out the services or provide the services. Having said that, our recommendation initially was to deny, since a special use permit would be required as a part of special use permit, the property owner or the resident that is providing the service is required to reside within the property. But I understand as of today that the petitioner has submitted some additional information or has indicated that they will provide additional information, and but we have not seen it. I would like to ask Ms. Brown if she has received, as of this afternoon, any additional information indicating that there are some changes in the case. If not, our recommendation would be denial.
I have not received any extra information, although the petitioner asked for this petition to be held. This is BZA 2024-10.
Yeah.
She asked for it to be held until the next meeting. Yes.
Any other comments, Mr. Ashami?
Nope,
Having heard staff recommendation to defer BZA 2024-10.
that wasn't our recommendation, Mr. President. Our recommendation was denial based
Having
on.
heard the
Yeah,
staff remit to us the petitioner's desire to have it deferred,
Right. That's correct.
is now the recommendation. Are there any, what is the pleasure of the, did you have something?
No, I said you need a motion.
Yeah, are there, what is the pleasure for the board?
I move for deferral.
Is there a second?
Second.
Having been moved and properly second to defer BZA 2024-10, are there any other questions or in readiness? Hearing none, seeing none, roll call, Ms. Brown.
President Bonds?
Yes.
Vice President Hawkins?
Yes.
Secretary Jones? Mr. Cook? Mr. Fawcett? With a vote of four yes and 1 abstain, the motion to continue BZA 2024-10 has passed.
Thank you, staff. Ms. Brown. Last item on the agenda, BZA 2024-11, 2424 Malcolm X Drive, commercial daycare use variance. Staff prepared for the overview.
Mr. President, the petition by Deborah Cooper indicating that they would be interested to develop a commercial daycare at this location, which is a residential area. And however, the use variance that is requested is for this facility, which is a home, almost home daycare facility. Again, there is a conflict here. I know the council has been discussing this issue. We have been discussing this issue, and I understand the petitioner is here. Our recommendation for this case would be to denial, or if the petitioner agrees to withdraw it and submit a proper petition. And I do also want to ask the council to make any comments that they may, that he may feel necessary.
Thank you, council.
And again, if the petitioner is interested to do a commercial daycare, that is not also acceptable within that residential area.
So for clarity, unless you weren't finished, Mr.
We are finished,
Arshami,
yes.
what was staff's recommendation?
Our recommendation is unfavorably recommended for approval.
All right. I also think I heard you say the petitioner is present to speak. Ms. Cooper, please step forward if you wish to speak. State your name and address for the record.
Deborah Cooper, I live 1131 East 19th Avenue, Gary, Indiana.
All righty. You may proceed. You may proceed if you wish to speak.
I'd like to turn to my, another house that I was renting, but now the lady's selling her home, and this is my first time buying my own house, so I want to put my daycare in the house that I own. And I'd like to make a, daycare plus a library, because in that area, we don't have library for children, so I'm trying to make it safe for where the kids can have a daycare home to come to and a library. Same thing.
Okay, and that address is not the address in question. That address is not the address in question.
The 2424, which
Right.
is, Macklemack Street, that's the one.
That's the house you're buying.
Yeah, no, that is my house. The house I live in, the house I don't live in is someone else's house. So I got, the 2424 is my house.
That,
So that's the one I want to use as a daycare. No, I don't live 2424.
okay. That
Oh,
is the
no,
issue.
sir, I don't live there.
Okay. Were you, Mr.
Yes,
Jones.
Ms. Deborah,
Yes, sir.
do you have any plans for moving into that house? Because one of the requirements for the residential daycare is that you have to be living in that property. And I understand your situation. I know you live on 19th Avenue. So the question is, are you planning to move into that house?
No, sir.
Thank you.
All right. Thank you,
Not
Ms.
thank
Cooper.
you. He tell you thank you.
Thank you. I misunderstood you, I'm sorry.
That's okay. Thank you, Ms. Cooper. Are there any other questions or comments from the
Mr.
board?
Chair,
Mr.
I'd
Cook.
like to know again what staff's recommendation was.
Staff recommendation is to unfavorably
Okay.
or to deny the petition. Go ahead, counsel.
I just want to clarify real quick. The denial, Mr. Ashami, if you could come up, just to clarify what the denial was based on. The denial that we had was based on the fact that the individual, it was not clear whether or not the individual was going to be actually residing in the house. Ma'am, do you have a tax exemption, a homestead exemption on this home?
A tax exemption, the house I live in, or
Yeah.
the daycare house?
Yes.
Yeah, I pay.
No, do you have a homestead exemption, meaning that you own the house, correct?
Yes,
Have you provided a deed
yes.
to the individual, to Ms. Brown? Have you?
Yes, yes, sir.
And that's the only home that you own, right?
No, sir.
Okay. What home do you have your homestead exemption on?
The 2424.
That's what you have.
1117, I don't own.
No. A homestead exemption, when you buy your home, it's essentially the exemption that you get on your property taxes that because you live in the home. It demonstrates that you live in the home.
Oh, no, I purchased a home on 2424.
Yes, I know that. It's not whether or not you purchase it. You're the owner of the home. You have to pay property taxes.
Yes, I paid the property taxes, yes, sir.
As part of that, if it's the only home that you own, you should have a homestead exemption on it. If you could,
No, I have another home I have a homestead exemption on.
okay, that's what I'm trying
Yeah.
to get at. Where's
on
that?
1131 where I live at, I have a home exemption on that.
But you don't own that home?
I own that home too.
Okay, that's what I was trying to get at.
Yeah.
So, but you're saying you don't live in that home?
No,
No.
24,
She
no.
don't live in 24. She owns 24.
Yeah.
She also owns 11, whatever.
Yes.
She lives there.
Yes.
That's where the homestead exemption is.
Yes,
Okay.
yes, sir.
So the denial for the special use would be based on the fact that you're not eligible for a special use here. With the special use, you would have, in order to use that home as a daycare, it would have to be a homeowner occupied occupation, meaning that you are operating, you live there, and you're using it as a part of a business that you're operating, you would need to apply for a use variance for using your 2424 as a commercial daycare. You know, it's in a house, but since it's not being used as for residential purposes, it would be considered a commercial establishment. Without a residential use part of it, that would be considered a commercial establishment. So therefore, you're not eligible. The recommendation from staff would be denial because you're not eligible for a special use permit. It would have to be a use variance.
So we have to live in a house now to have daycare? That's what you're saying?
If you,
For home daycare.
for a home daycare,
Oh, y'all changed the law?
no.
No, it
No,
never
no, no.
changed.
But I'm living with my other resident.
Based on how you live and where you live, you are not eligible for what you have requested. The request should be changed. Is that not correct, Stan?
Actually, yes, and yes. Here is the issue. Here's the issue. Number one, even if you were able to, Ms. Cooper, be approved in the past, you probably shouldn't have. Because of the statute, what Attorney Pohl is saying is there's criteria, ordinances and statute, that provide as to when you can have a daycare. It has to be a home daycare, a home you live in with the homestead tax exemption on it. If you have a second or a third property, you can't move that exemption to those other homes. They become what's called secondary homes or rental property where they don't have the homestead. So it doesn't qualify. Now you're looking for a commercial daycare and you have to apply for a use variance. Here's the dilemma beyond that. The supporting documentation says use permit. The agenda does say commercial daycare use variance.
Well,
So it's like, it's, the supporting doc is you can't do it. And,
because of commercial,
yeah, because it's considered commercial. You can't use the use permit.
I never said my house was gonna be a commercial.
you have
Ms. Brown, I put in as a daycare, not
Right,
commercial.
again,
So
but you
But it
don't
would be-
live at 2424.
Yep. So a daycare is, so ma'am, to clarify, even if you're operating a daycare in a house, it's considered commercial if it's not being used as a home, as a residence.
Right.
So when you have the zoning districts, you have a residential
Yeah.
area and everything in there can only be residential. What you're trying to do is use a house in a residential area as a commercial business because nobody lives there. Now you've changed the use that house is to commercial. It's only being a business, right? That's the issue. That's, and by our, we have our zoning laws that state that, in order for that to be allowed as a special use, as a daycare, the way that that's always been applied is that the individual has to live in the home because it still has a residential purpose. Otherwise, if I use my house as a restaurant, I turn my house into a restaurant and I've got people coming and going all the time, and I don't live there. I've just turned it into, to a restaurant. People in the neighborhood are going to take issue with it. I've now broken the zoning laws because I don't have the approval to operate a restaurant in a residential area. Daycares are no different, except if you live in that daycare or you live at that home, then you would be eligible to apply for a special use permit. Here, you're stating to us that you don't live in that home. You're only using it for a business.
I'm not gonna lie and tell you I do when I don't.
No, I know, that's
Because I got
you don't expect
daycare.
anything.
I mean, I done seen people don't even live in their house and have daycare, so I'm
And-
kind of confused on this one now.
No, the problem is that shouldn't be.
Yeah.
And maybe they got through the cracks.
No, because the
Years
laws
ago.
change. I mean, every
No.
so years the laws change with daycare. So
The idea of Ms. Cooper, right? Is it Cooper?
yes, sir.
All right, Ms. Cooper, the idea is this. If it's a home business, it's a business that is operated out of your home where you sleep and live. If you don't sleep and live there, it's not a home business. It's a business that you're operating out of a house, which is not allowed.
Yeah, and the other issue too is individuals, this goes to the point that I was making earlier, individuals may have come in here, requested a special use permit, lived in the home, and then moved out of the
Right.
home. And that's another issue. That's something that we have to take care of on an enforcement side from when they come and get their business licenses. We should be demonstrating that those individuals still actually live there, that they haven't pulled the bait and switch on
So
us.
it's not that the laws change, what it is that they're now being properly enforced. Because if not, you can take a 10-house block and just operate how you want. The zoning code or the appeal is to be an exception, something that's not always normal, not the norm. If we allow, even if we did it and we violated statute, and allow what everybody wants, then every house on the block would be a home daycare, whether you live there or not. I can live in Crown Point and all 10 of those houses can be my daycare. Now what you've done, you've changed the neighborhood use from residential to a business district, and that's not allowed.
Oh, so you can't change the house into a commercial. It got to stay.
It
This
has
house
to-
was
it's-
with
it's-
me
it's-
living in there body
Is
wise.
predicated on what's already voted on and approved in a zoning map council. And we're gonna cut this short after this.
Yeah, just to be clear, you could do so, but you have to, one, request the correct thing. You requested a special use permit, and we're telling you that you're not eligible. She did? Okay, so if you applied for a use variance.
Okay, so now,
Totally di-
here's the, and which is why I brought up the fact that the
It says-
supporting doc had, I thought, it says special use permit at the top of the document. But the agenda item says
Commercial daycare.
commercial
use
daycare use. Within the body of the document, however, which is what I was about to get to, you still would be denied, even if you petitioned as a special use because of the lack of the hardship. There's not a hardship there. Meaning, there's no reason to change. You could put that business someplace else where it actually belongs, as opposed to a residential neighborhood. What it essentially means, you cannot come before the Board of Zoning Appeals and request to change a neighborhood's context from what it's already ruled or judged to be by ordinance. If they make a neighborhood a residential neighborhood, that is all that can be there. If you live in that house and you say, hey, I want to have a home daycare where I live there, okay, apply for a special use variance, petition and make your case. If you're saying I live in California, Africa, New England, wherever, and I want that house in that neighborhood to be a commercial property, the answer is no, unless you can prove that there's a hardship that should allow it. And in this case, the document says no to that. The answer is going to be no. Well, the recommendation is going to be no either way, is what we're saying here.
So it just have to stay up, rental property and no daycare.
We can't give you that advice, but that is an allowable use.
So this is not the end of the road. What happens is if the board still has to vote. And ultimately, in this instance, if you cannot demonstrate a hardship, it'll get, there's the potential that they will vote unfavorably. If they vote unfavorably, it'll go to the council. You'll have the ability to go before the Gary City Council and explain why you do believe that there is a hardship. At this point right now, I mean, this would be your opportunity to explain why there would be a hardship. And I apologize because I'm going off the documentation that we had provided. It says special use. That's why I kept saying that you weren't eligible for that. A use variance is different, and that's what you're requesting. The issue that we consistently have with daycares that apply for special use variances, for use variances, not special uses, but use variances, is ultimately one of the elements is that they have to demonstrate that there's a hardship. That is, if the laws were applied strictly to your property, meaning that it was residential, that for some reason that you could provide to the BZA, that would do a hardship to you. Owning the building itself as a house and saying, well, I bought this because I wanted to open up a daycare is not a hardship. Is there anything else particular to this property or to your circumstance that you believe would make, the denial a hardship for you.
Yes, because it's someone else's resident, it's not mine, and I lived in that house like 30-some years. But
So,
the-
Ms. Cooper, this is what we're gonna do. I think what probably should have happened, and I'm certainly not blaming staff, so don't take it that way, but I think a better and more thorough explanation of what actually needed to happen. Because at this point, however it is written in the supporting documentation, the recommendation is denial. How it's written on the agenda, because of the hardship issue, the recommendation is going to be denial. It's not going to make it, chances are, past us. I think what you probably need to do is have it more thoroughly explained. I don't know that you have a good grasp of it, but at this point, it's not going to,
But I asked Ms.
be
Brown
recommended.
to explain it to me because I know people don't even live in their house and have child care. But I don't. Okay, but
I do get it, I do understand.
that's why I said.
Mr.
That's why I
Jones.
said, did the law change? Did something change? Because I done seen people don't even live in their house and have a daycare. Now, commercial part,
Well, until they are found and
that's crazy.
issued a citation,
Okay.
they're not here to be heard right now.
Okay.
So I do thank you. Mr. Jones, I keep wanting to say commissioner. Oh, this is
Mr. President, I was wondering, could we defer this until a later date and give her a chance to see what she can possibly do?
The only problem with that, Mr. Jones, is what are we deferring? If you're deferring a special use permit and you don't live there, that is a denial. If you're deferring a commercial variance, there is no hardship, that also is a denial.
Just to make clear, she applied for a
Okay, well,
That's what this reads, commercial daycare use variance.
okay, well, that's correct. Do I have are we on 2024-11?
Yeah.
We reading what's at the top?
the agenda, what is on the agenda.
Is correct. All right. What's on the agenda is correct, and what's in the staff recommendation coincides and is correct. As such, the recommendation of staff is to deny a variance of use for the lack of a hardship. Then that just simply means the label of the supporting documentation is an error, but it's still, the recommendation is denied because you lack a hardship. And you probably don't have a full grasp of what that is.
No, because
So we're going to take this vote because we can stay here 2-3 more hours and we're going to do the same thing. And what I would encourage you to do after this vote is taken, to go back to staff if you have any questions. There's no need to defer. And then thereafter, you could still go to the council and try to plead your position. You understand?
Yes, sir.
Thank you very much. Staff recommendation is to deny the use variance. Having heard or read that, are there any questions or unreadiness? No. What is the board's pleasure?
Mr. Chair, I'd like to vote that or rather make a motion that we accept staff's recommendation.
Is there a second? Second. Having been moved and properly second to accept staff's recommendation to deny, are there any questions or unreadiness? Hearing none, seeing none. Roll call, Ms. Jones.
President Bonds,
Yes.
Vice President Hawkins. Yes. Secretary Jones,
Yes.
Mr. Cook,
Yes.
Mr. Fawcett.
Yes.
With a vote of 5-0, the motion for BZA 2024-11 to have an unfavorable recommendation has passed.
Thank you, Ms. Brown. Last item on the agenda is adjournment. What is the board's pleasure?
So moved.
Having been moved, is there a second? Having been moved and properly second, Mr. Arshami. Okay. All those in favor signify by saying aye. All those opposed, hold the same. We are adjourned. 12 will be heard when it's on the right agenda. It's out, it's done. We could have.